Here we all are. Thank you for coming here, a small but very select group. I'm Robert Carnwath. I was an associate of Landmark. I was in the Supreme Court a few years ago now. And this is our first part of our seminars on climate change and human rights. And they follow, of course, an interesting judgment in the European Court of Human Rights. And we have a session today with three expert speakers, starting with Miranda Butler, who will tell us what the court decided. And then we'll have Goodman KC, who will talk about the question of standing and victim status and how that's been developed by the court in this decision. And then we'll have Turney KC about the Article 6 right to fair trial aspects. And then next week, there'll be a second part, which will be looking at the sort of domestic implications. Now, I'm not really here to speak, but it's a great interest to me in this because I've been taking an interest in the subject for some time. Back in 2015, when I was in the Supreme Court, we organized a seminar ahead of the Paris conference on climate change in the courts. We had speakers from different parts of the world talking about the sort of judicial aspects. We had two really interesting cases then. One was a case in Holland called Agenda in the Netherlands, which was about how one could, an NGO could require the state to fulfill its commitments. And the court made a very far-reaching decision saying that it could be compelled to do so. That was, at that time, initially made under a rather obscure part of Dutch law, which I certainly didn't understand, but later it was upheld by the Supreme Court on the basis of the European Convention of Human Rights, which I think some of us thought might not work. So it's quite interesting to see where we've got to now. The other one was the Leghari case in Pakistan, where the Lahore High Court made an equally sort of impressive decision based on the constitutional right to life under the Pakistan Constitution. And we had a very interesting discussion about those. But of course, since then, we had the Paris Agreement, and we've had a great development of case law. But it's of interest that in the last month, both those aspects have developed. There's been a very interesting case in the Supreme Court of India, which has confirmed that under the Indian Constitution, the right to life, the state has a duty to take steps to protect people against the effects of climate change. That's certainly worth looking at, but we're not going to be discussing that today because it's not directly relevant in this jurisdiction. But then we've had this decision of the European Court of Human Rights, which has settled, I think finally, that there is a human right under the Convention to be protected from the effects of climate change. And so that's what we're going to be looking at today. And I personally will be very interested to hear what active practicing lawyers think is going to come of all this, and we'll have a chance for discussion afterwards. So we'll start off then. They're all three distinguished speakers. Their biographies are on the Chamber's website. I'm not going to go into them here because they would go on too long. So over to Miranda to start us off.
Thank you very much, Lord Carnwath. So I'm going to hubristically try and talk about what the court decided. It is a 260-page long judgment, so we'll be here until midnight, everybody. I hope you all brought your dinner. I'm naturally going to focus in particular on the Article 8 and Article 2 key findings, with Article 2 necessarily taking less centre stage. Excuse me as I get used to my clicker. I'm going to leave Article 6 and issues of standing to the other speakers today. And then if you come along to the sister event that we're going to be having next week on the domestic context to this, there will also be some discussions of the dissenting judgment from Judge Eicher. So to start by talking about the background to the judgment in Verein, Klimaseniorinnen, Schweiz. This is the key judgment I'm going to be talking about today. There are two related applications that I'll touch on more briefly, but as this was the successful challenge, unsurprisingly, it'll be the focus of my talk. This was a challenge brought by 4 older Swiss women and an organisation based in Switzerland made up of older Swiss women concerned about climate change. In particular, both the individual applicants and the association were concerned about the consequences of the climate emergency on living conditions and in particular their health. And we'll come on to touch on the fact that there was evidence adduced about the impact of, in particular, heat waves on this particular group. So the claim starts all the way back in 2016 with the applicants requesting that the Swiss authorities act and take steps to address their failings when it came to climate protection, and sought a decision that action be taken in particular in compliance with the 2015 Paris Climate Agreement. That request, indeed those series of requests, were treated as inadmissible in 2017. Not only was the reason given that the applicants were deemed not to be directly affected, they were also criticised for the fact that they were essentially seeking worldwide CO2 reductions rather than just locally, with the federal bodies noting that given the global nature of emissions and of climate change, it was impossible to disaggregate the effect of local emissions from what is going on around the world. The applicants appealed to the administrative court unsuccessfully. The court found that older women were not the only population group affected by climate change, and they couldn't show that they'd been specially or differently affected. Finally, we come on to the decision of the Federal Supreme Court as the applicants appealed onwards, again unsuccessfully. It found that the individual applicants weren't sufficiently or directly affected by the alleged failings in relation to their convention rights. So unsuccessful all the way up domestically. And you see here a number of the problems with which the court then had to grapple when the applicants went to Strasbourg. You see here issues of causation, given the global nature of climate change, questions of individual responsibility for nation states, again, given the global burden sharing, and also questions when it comes to victim status and individual impact, which Alex will touch on more in his talk. So we come to the complaint that was formulated in Strasbourg. The applicants challenged various failures by the Swiss authorities to mitigate the effect of climate change by putting in place adequate domestic, legislative and other measures to reduce the impacts, which they said posed risks to their life, thereby arguing that there was a breach of their rights under Article 2, and also to their private, family and home life protected by Article 8. In particular, they complained that Switzerland had failed to introduce suitable legislation or put in place appropriate and sufficient measures to meet the targets, in particular, the targets agreed in the Paris Agreement for combating climate change. They also made complaints under Article 6.1 and regarding effective remedy that I'm not going to go on in any particular detail. As I mentioned, this wasn't the only set of applications that the Strasbourg court had to deal with when it came to climate litigation recently. Whilst Verein Klimaseniorinnen was granted priority, this was done together with 2 other cases, Carnwath versus France and Agostino versus Portugal. There was no formal linking of the applications, but the hearings were staggered and the cases were all heard by the same composition of the Grand Chamber. So in Carême, the former mayor and former resident of a town in northern France, which is liable to, essentially at risk from rising sea levels, The court found that the former mayor didn't have victim status because he'd since become an MEP, and so was not only not living in Carnwath, he was not living in France anymore. Similarly, the Agostinho case, which was a case brought by young people from Portugal, brought against both the Portuguese authorities and 32 other Council of Europe states, was also unsuccessful on procedural terms. In particular, the court held that they'd failed to exhaust domestic remedies. They'd gone straight to Strasbourg without making domestic applications, notwithstanding domestic laws that allow for a right to a healthy environment in Portugal. So not only had they not exhausted domestic remedies, the court also held that their application was inadmissible as regards the other states because there was no basis for extending the ECHR's territorial jurisdiction. And the court commented in the Agostinho case that whilst there'd been an argument that extraterritorial effect in the context of climate change should be more broadly interpreted and applied, and should be applied where other states had sufficient control over their convention interests, the court said this would lead to a critical lack of foreseeability in the convention's reach. It would lead to far too much uncertainty and would essentially be an unwarranted and unlimited expansion in extraterritorial jurisdiction. So again, we're seeing here some of the issues that the court had to grapple with and will in future have to grapple with in climate litigation, both as to victim status, but also as to how to make such climate protections as the court may find workable. So moving back to the successful case, in this case, the court made positive findings that there were violations of the association's rights in relation to Articles 8 and 6. The court referred to the case as being unprecedented and clearly sees it as a groundbreaking case making new law. And I think it's very fair to say that this can probably be described as groundbreaking. I've seen some people carping and saying, oh, it's not really that new. We've had case law that found environmental protections under Article 8 previously, and I leave that to cleverer people to work out quite how novel it is. Certainly the court thinks it's novel. And the court is very aware of what it's doing, so it has a lot of preamble before it reaches findings of violations. I've already mentioned it's a very long judgment, and in part it's lengthy because the court takes its time to set the scene very carefully. It wants to be clear about the context in which it's working and what it's trying to do in finding states responsible for failings in relation to mitigation and adaptation to climate change. So the court does note the science on climate change. It notes the reality and urgency of the climate crisis, referring to it as one of the most pressing issues of our time. It also notes the long-term impact of climate change, referring to the intergenerational burden sharing, to put it more simply than the court does. The impact is going to have on our children and on our children's children. The heavier the burden will come over time, especially if urgent action isn't taken by states today. It also notes the impact on vulnerable groups, including, of course, older women, in the particular context of this case. However, the court's also keen to emphasise that its role is necessarily limited to enforcing states' compliance with the convention. It's not here to try and enforce the Paris Agreement wholesale, nor is it trying to legislate or act as the government. Those who are critical of the judgment may say it does exactly that. And again, I leave it to wiser heads than mine to decide whether they're right. But the court is very careful to emphasise that they cannot substitute for the action that states need to take at a domestic level. But notwithstanding that acknowledgement of the limitations of the court, it also recognises that climate change poses sufficiently real and direct threats to the enjoyment of convention rights that warrants the court's interference. There's still more preamble. There's plenty of preamble in this judgment. the judges go on to talk about the complexity of causation in these cases and understands the fact that we've already touched on, that it isn't the case that the climate-related impacts that the members of Verein, Klimaseniorinnen are going to experience are the direct result merely of actions or inactions by the Swiss authorities. They recognise this is a global issue. They also recognise that while a global response is needed, that does not reduce the obligation of an individual state to take reasonable measures to tackle climate change locally. That doesn't amount to a finding or a rule that states are obliged to comply with all of their environmental rules in such a way that any failure to do so would lead to a breach of the ECHR. But nevertheless, the court is clear that states have to have reasonable measures which can be taken that have a real prospect of altering the outcome or mitigating the harm that can be caused by climate change. And they refer to other court case law that recognises that you don't need to show but for causation to find a breach of the convention. You don't need to show that but for Switzerland's actions regarding climate change, there would not have been climate change problems in Switzerland. You need to show that that their actions could have had a real prospect of impacting the outcome. Again, still in the preamble, the court talked quite a lot about the margin of appreciation in this context. It makes sense to do so, given the intensely political and polycentric nature of decision-making that we're looking at here. Given the fact that the court decided to deal with the key issues through the lens of Article 8, what it seeks to do is to foreground the need for the states to set clear, realistic, specific aims and objectives. And that is something where they'll have a lesser margin of appreciation. They need to recognise that climate change is a problem, and they need to have a framework sufficient to meet that. However, when it comes to operational decisions, when it comes to how you achieve those targets, it will have a greater margin of appreciation. And in making those decisions, states will be required to give considerable weight to the importance of climate protection. So coming on to the key findings that the court makes, the court does attempt to position its decision against the backdrop of Article 8 being used to deal with environmental problems that are deemed to affect convention rights. However, it builds on that and, to my mind, clearly makes new law by finding that Article 8 encompasses a right for individuals to effective protection by states from the serious adverse effects of climate change on their lives, health, well-being, and quality of life. And within that context, the court finds that there is a positive obligation to adopt and effectively apply in practice regulations and measures that are capable of mitigating the existing and potentially irreversible future effects of climate change. And now I'm going to read out a couple of key passages because I think it's best to see how the court has put its key reasoning and its key conclusions in its own words. So what this judgment finds is that states need to put in place the necessary regulations and measures aimed at preventing an increase in greenhouse gas concentrations in the Earth's atmosphere and a rise in global average temperature beyond levels capable of producing serious and irreversible adverse effects on human rights, notably the rights protected by Article 8. In order for this to be genuinely feasible and to avoid a disproportionate burden on future generations, immediate action needs to be taken and adequate intermediate reduction goals must be set for the period leading to net neutrality. And so that is the core of the demand that this judgment is going to place on states. So what needs to be done is not only to have a clear target, to have in place regulations and measures aiming at preventing the increase in greenhouse gas emissions, but you also have to have your intermediate reduction goals. So again, it comes back to that word effectively that they use. This isn't aspirational. You need to show that you're taking it seriously. You need to show that you have a realistic framework for it, although how exactly you do that will come down to states' individual decision making. And it found a violation in the case of Switzerland because of the absence of a satisfactory regulatory framework. So there were a number of what the court called critical lacunae in Switzerland's domestic framework. In particular, there was the absence of a carbon budget, and there was the absence of any legislative framework for reducing emissions between 2024 and 2031. Those are the findings under Article 8. Notwithstanding the fact that the applicants adduced evidence showing a link between climate change and increased mortality, the court refused to deal with the Article 2 issue, not refusing to find a violation, but preferring, perhaps in a bit of a fudge, to deal with this through the lens of Article 8 on the basis of the absence of any real or immediate risk to life due to climate change. The court recognised that Article 2 claims could, in principle, succeed, but refused to make such a finding in this case. And whilst this might be seen as a fudge, I think it's quite fair to say the court feels much more comfortable in a hotly political, highly complicated, technical, scientific, political arena dealing with this through the lens of a qualified provision, not the absolute terms of Article 2. So following, just concluding on that whistle-stop tour, this is a judgment which builds on the environmental protection we already saw under the court's case law. The court recognised that this was a novel case and took the opportunity not to kick it out on procedural terms as had been done with the other linked cases. It once again uses Article 8 as the crucible for new rights, and as I said, as I've already indicated, perhaps fudges the Article 2 to allow it to give us that preamble, to give us the context, and to look at this in a way that seeks to balance the urgency of the situation with the need to place realistic and manageable obligations on states. That's not to say that no Article 2 claim could ever succeed, but you'd need much clearer and I'd say stronger facts. And my takeaway from this is that whilst the court is going to show substantial deference to states as to how to address the climate crisis, they need to show they're trying. It will not defer to them when it comes to recognise the importance and urgency and setting workable targets in the short, medium and long term. Thank you very much. I'm now going to hand over to Alex, who is going to talk to us about the victim test.
My talk's about standing or victim status. The European Court, consciously and expressly expanded the former understanding of who qualifies under Article 34 of the Convention to bring an application to the court. The effect is that associations in cases concerning climate change, but probably not in any other case, in related areas, and subject to a number of other conditions, can bring claims before the European Court of Human Rights. At the same time, the court rejected the applications of each of the individual applicants who were themselves all members of the association, which was granted victim status. In the individual cases, it rejected each case on fairly conventional grounds that they had failed on an evidential level to establish that they were victims. So I propose to look at what the court decided and then to consider how that will affect the ability of associations, which is their word, but would presumably encompass not just associations as we think of them in the UK, but also NGOs, the ability of associations to bring a human rights claim in the UK. My tentative conclusions will be that the European Court has expressly stated that its expansion of standing is limited to cases concerning human rights and climate change, and so won't affect human rights cases outside of the climate change arena. But that nevertheless, its ruling is not going to be easy for UK judges to ignore, And my view is that there are some real potential consequences for the victim test under Section 7 of the Human Rights Act 1998, and indeed a question whether it's actually going to need to be read down in light of the judgment of the court, because as it's understood currently under our case law, may no longer be compatible with the convention as it has dynamically now evolved. So I'm going to start with what the court decided in the Swiss case. Just first of all, it's very straightforward. This is a standing provision, Article 34 of the ECHR. The court may receive applications from any person, non-governmental organisation or group of individuals claiming to be the victim of a violation by one of the high contracting parties of the rights set forth in the convention. So that's the wording that the court is concerned with, claiming to be the victim. And that word victim then also appears in our Human Rights Act. So that's the question. Who is a victim? So as regards the individuals that came before the court, there were 5 of them. Each of them was an elderly woman from Switzerland alleging victim status because they said there was an impact on their right to respect for their private life, meaning their health primarily, caused by climate change, particularly from the increasing incidence of heat waves. And it seems Switzerland actually experiences a greater proportion of the impacts of climate change than the average, because their temperature rise is already well above 2 degrees in Switzerland, whereas globally we're at something like 1.1 above pre-industrial mean. So the court found all 5 claims to be inadmissible. The tests it applied were conventional ones, judgment paragraph 487. The applicant had to be personally and directly affected by the impugned failures. That means A, the applicant must be subject to a high intensity of exposure to the adverse effects of climate change. That is, the level and severity of the risk of adverse consequences of governmental action or inaction affecting the applicant must be significant. And there must be a pressing need to ensure the applicant's individual protection, owing to the absence or inadequacy of any reasonable measures to reduce harm. And it said at paragraph 488 of its judgment, the threshold for fulfilling these criteria is especially high. In view of the exclusion of actio popularis under the convention, so that means public interest litigation can't be brought under the convention. In view of the exclusion of actio popularis under the convention, as discussed in paragraphs 483 and 484 above, whether an applicant meets the threshold will depend on a careful assessment of the concrete circumstances of the case. In this connection, the court will have due regard to circumstances such as the prevailing local conditions and individual specificities and vulnerabilities. And then at 531, it held that while the applicants belonged to a group that was particularly susceptible to climate change, i.e. the elderly, that was not of itself enough to grant them victim status. It was necessary to establish in each case a particular level and severity of adverse consequences affecting the applicant. In essence, the court found that none of the individual applicants had on the evidence presented met these tests, and so none were held to have standing. However, despite the findings that none of the individuals had standing, it nevertheless held that the association of which the 5 individuals were part did have standing. Now that's been subject to some fairly, I would suggest, slightly superficial criticism and commentary, which is essentially, well, how can no standing plus no standing plus no standing be associated into standing? But I think there is a deeper answer to that, which I'll perhaps explore at the end. The association in question was a small campaign organisation. It's about 2,000 members. All of them were women over pensionable age, concerned with the rights of people over the age of 70 affected by climate change. So this is where the court has developed its case law on standing, and this is about standing of what the court calls associations. And this is what it said at 498. The specific considerations relating to climate change. Now I've highlighted specific considerations because it repeatedly uses this word specific considerations, specific content, context, etc. So it's making very clear that this isn't a judgment it expects to bleed out into other human rights cases. It's a judgment concerned with the particular and specific context of climate change, i.e. that being one in which there is a global context and a global set of issues that are difficult to address otherwise than by this approach. The specific considerations relating to climate change weigh in favour of recognising the possibility for associations subject to certain conditions to have standing before the court as representatives of the individuals whose rights are or will allegedly be affected. So again, underlying the representative function, you have to have individuals whose rights are or will be affected. So what you can't do as an NGO, Greenpeace, Friends of the Earth or whatever, is allege in the form of an actio popularis, i.e. as a general public interest piece of litigation, an incompatibility with human rights. You still have to anchor it in the impacts on specific individuals. Now, the Swiss case was dealing with 2,000 individuals, so they got through this hoop, but it's an important qualification. Indeed, as the court previously noted, it may be possible for an association to have standing before the court despite the fact that it cannot itself claim to be the victim of a violation of the convention. Now, that's a key phrase which I'll come back to for the UK, because it's that inability of associations or NGOs to claim that they are victims which has enabled the courts to screen out human rights challenges by NGOs in the UK. But the court here making clear that not being a victim yourself, and even none of your members having shown evidence that they are specifically a victim, doesn't necessarily exclude you. The court therefore considers it appropriate in this specific context to acknowledge the importance of making allowance for recourse to legal action by associations for the purpose of seeking the protection of the human rights of those affected, as well as those at risk of being affected by the adverse effects of climate change, instead of exclusively relying on proceedings brought by each individual on his or her own behalf. So it's expressly repudiating and rejecting the approach advocated in the partly dissenting judgment of Tim Icke, the UK judge on the court, in which he advocates that they should have continued to rely exclusively on proceedings brought by individuals and should have just waited until another case came round. So actio popularis remains impermissible. That means that abstract complaints about deterioration of living conditions of people without considering its impact on a particular person or group remains inadmissible. And these are the conditions that the court set up at 502. The association must be lawfully established in the jurisdiction concerned or have standing to act there, must be able to demonstrate it pursues a dedicated purpose in accordance with its statutory objectives in the defence of human rights of its members or other affected individuals within the jurisdiction concerned. And C, must be able to demonstrate it can be regarded as genuinely qualified and representative to act on behalf of members or other affected individuals. So those are the sorts of considerations we'd be familiar with in relation to standing in an environmental judicial review, in fact. So there's some sort of crossover with concepts that we're familiar with in our domestic standing jurisprudence. Judge Icke, in his partly dissenting opinion, accepted the principle so that in principle the standing test under Article 34 could be expanded. He said that's implicit in the principle of effectiveness. So he accepts the idea in principle that in order for the convention and the court to be able to provide effective remedies, there can be what the court calls an evolutive approach. But he took the view the court should only do so where that was necessary because no individual could bring a case. And he made the point that the individual applicants only failed to prove their standing on the evidence. There was nothing intrinsically impossible about a different applicant coming forward. So they all just produced weak claims. That's what he was saying is, well, why are we jumping ahead to actually deciding this issue when each of the individual applicants, it's not suggested they couldn't have done better, they just didn't bring a good enough case to establish their standing. And so he thought expanding the standing provisions to allow an association to bring a claim was unnecessary and should have been left for an appropriate future case. I think I've got time to interpolate my own opinion on that, because this is where the controversy in commentary has focused, whether you know, obviously those who are opposed to the judgment have aligned themselves with Icke. And I think clearly his approach is obviously a more orthodox expression of the gradualist, evolutive approach that we're certainly accustomed to, both in the European level and certainly in the UK. But it does seem to me to lack a certain element of practical sense in regard to the reality of the situation, because what he's saying is there's nothing impossible about another applicant coming forward. Well, the reality is the case they decided turned on events going back to 2019 and 2020. So if they're going to wait again, they were going to say, bear in mind, this wasn't even the only case in front of the Grand Chamber on climate change at this point. All of the others lost on inadmissibility points as well. This is the only one that made it through. So this would have been another one found inadmissible. The message they would really have sent is, we're going to find all these climate change cases inadmissible. Don't really bother us with them. That's the message that would have gone out if they'd rejected every single one of them on technical points. You have to bear in mind that what the court actually found in substance was a breach of human rights. So what Judge Ike is actually saying is, even though there was a human rights breach in the view of the Grand Chamber, they should have thrown it out on a technicality, because it would be better to have a gradualist approach to rules on standing. And when you put it like that, the balance doesn't seem quite as obvious as some of the commentariat suppose. When people come to consider how this generation failed on climate change, they're going to be quite concerned with the overarching failure, but the question of whether the court should have expanded in a very minimal way its rules on standing is going to be of very little interest. So it's actually quite a radical perspective that the court should come to the view that there was a breach of human rights and yet should have thrown it out on a standing point, rather than make a very, very small and, I would say, quite incremental advance in its standing rules. So I think that's the counterpoint perspective to those who say the court's gone beyond its remit here. Implications for the UK then, quickly on this. So, but this is the interesting and challenging part for the UK, because in the UK domestic law, jump ahead one slide, there's a couple of cases that illustrate the UK approach on standing. The Reprieve case, this was about rendition. Reprieve tried to suggest that under the Article 3 investigative duty, so Article 3 protects against torture, UK authorities were involved with rendition, that is kidnapping people and handing them over to foreign states that tortured them. There should have been a statutory inquiry into what went wrong, because there's an investigative duty under Article 3 to ascertain how the state ended up complicit in torture. Court threw that out and said, you don't have standing, you're not a victim. Another example is the Adath Yisrael Burial Society. That's actually an association. It's it's not an incorporated group. So it's, I think, quite similar in a way to the Swiss case. They challenged the burial rules around Jewish burials being treated in the same Orthodox Jewish burials as all other burials, yet their religion provided for a very swift process, and that wasn't being accommodated by the coroner and the burial authorities. Their human rights challenge was an Article 9 challenge based on their right to religious freedom. Again, Lord Justice Singh and Mrs. Justice Whipple, as she was, said, you don't have standing, you're not an individual victim. So that's the kind of response we get in the UK to NGOs, and there hasn't been any distinction drawn in the environmental context. In other words, we apply a fairly straightforward interpretation of Section 7 of the Human Rights Act, which says this: a person who claims that a public authority has acted in a way which is made unlawful by Section 6 may bring proceedings up against the authority under this Act in the appropriate court or tribunal, or rely on convention rights or rights concerned in any legal proceedings, but only if he is or would be a victim of the unlawful act. And then Section 7.3, sufficient interest in judicial review is said to be established if you are a victim. And subparagraph 7, for the purposes of this section, a person is a victim if he would be a victim for the purposes of Article 34 if proceedings were brought in the European Court. So our domestic victim test is made by reference to Article 34. But our learning is that to be a victim, you have to be an individual. So it does seem to me that the courts are going to have to, in the context of climate change alone, because I think it's been very specifically demarcated that way, are going to have to revisit what Section 7 means, because for the purposes of Article 34, suppose you had the very Swiss case, but in the UK. So you had the very same association or its UK branch brought the very same claim. Forget the merits of it, but would they have standing? Well, under our existing domestic case law, the answer is no. But clearly, they would have a strong argument to say you need to revisit that in light of the European Court of Human Rights judgment. Now, if the courts found that they've encountered some difficulty in expanding the meaning of Section 7, where does that leave us? And it seems to me it raises quite an amusing prospect that Section 7 itself might be incompatible with Article 8 of the European Convention on Human Rights, meaning the court would be acting contrary to those Article 8 rights in applying a strict interpretation of Section 7, i.e. acting unlawfully under Section 6. And so the court would find itself bound by Section 3 to read Section 7 compatibly with the Convention rights. That's the duty to read down legislation so as to produce a compatible outcome. So you might find that the Human Rights Act itself ends up violating human rights unless you change the interpretation of Section 7. I don't know if that's a mad idea, but it occurred to me when I was just preparing this. I think one of the answers may come back to this so-called mirror principle, ULAR, and all the many, many cases that have gone to the Supreme Court subsequent to that about how we relate to Strasbourg jurisprudence. You have to keep pace with it, etc. Don't go beyond it is the main principle, but keep pace. And I finish with Lord Bingham's observation in the Denby High School case that the purpose of the Human Rights Act is not to enlarge the rights or remedies of those in the United Kingdom whose convention rights have been violated, but to enable those rights and remedies to be asserted and enforced by the domestic courts of this country, and not only by recourse to Strasbourg. And so that reinforces the sense that the UK courts are going to have to catch up. So however much we might think that our judge, and in his partial dissent, was the one we might have preferred, that's not really how the system works overall, or the structure of the Act works overall. So we may see some movement on the victim test in climate change cases in the UK.
Good evening, everyone. So I'm going to move on to talk about the findings on Article 6 and the relevance of those. I start just with a quote from the judgment that we're concerned with, which is emphasising the role of the courts and the importance of access to justice in the field of climate change. So that's how the court starts their analysis of the Article 6 arguments, and noting that it's really for the domestic courts in each of the member states to form a view as to how they're going to give effect to these things, but nonetheless the court obviously has its supervisory jurisdiction in Strasbourg. So Article 6, I'm just going to set this in context of how the domestic courts here have dealt with Article 6 in the environmental context, particularly through planning, just to make sense of to what extent the Swiss case is going to change any of that. Obviously, the starting point is the provision itself. In the determination of civil rights and obligations, everyone's entitled to a fair hearing by an independent and impartial tribunal. And since the 1980s, the Strasbourg case law has indicated that that includes rights of a public or administrative nature. So in other words, enforcing public law obligations in professional regulation, licensing and planning. And the seminal domestic case, going back some time now, and there's a whole series of litigation about the planning system at the point at which the Human Rights Act came into force in 2000. There's a whole series of litigation and finally reached the House of Lords in, I think, in 2002, reported in 2003, in the Alconbury litigation. And I go back to this because when you look at domestic case law on Article 6 and the planning system and environmental regulation, it hasn't got much beyond. Perhaps unsurprisingly, that's the House of Lords laying down the law, at the start of the Human Rights Act regime, but it hasn't really been questioned or interrogated much since. But in Auchenbury, effectively, the reasoning is that, first of all, a planning determination or an environmental regulatory determination, there's a whole series of different matters being challenged, is a determination of the civil rights and obligations, at least of the person who's applying for the permit or the planning permission. And obviously that's seen in a very traditional sense, that they would have a right to use their property in a particular way, and if they're able to exploit that right through the grant of planning permission, then they can use their property in a different way. They're otherwise subject to state control and supervision on the way in which they enjoy their property. And the House of Lords in Auchenbury take the point, it's a bit begrudgingly that they accept the point, but for that case law from the 1980s in Strasbourg, they would have found that there wasn't a determination of civil rights and obligations, but they felt they were stuck with that, particularly Lord Hoffman, who has a bit of a complaint about that series of cases. And how do you get to the resolution of Article 6 with administrative decision making? Well, it's what has become known as the composite approach to Article 6, which is that you have an authority which can make findings of fact, and then you have provision for judicial review on normal JR principles. And together, you have the right of access to a court on the determination of your rights in respect of environmental regulation and planning. It would be wrong, says the House of Lords in Auchenbury, to substitute for the Secretary of State a different body to make those initial factual findings or decisions about how policy should be applied in a particular case. It would, they say, not only be a recipe for chaos, but it would be profoundly undemocratic. And it explains, the court explains the various competing interests, and the fact that the person who's best suited to weigh up those competing interests is the Secretary of State, and the Secretary of State is also the best person to set out policy with democratic accountability for that. And most importantly, the point to emphasise in that third bullet, the requirements of Article 6.1 are met through judicial review. So it doesn't matter that you don't have a court where you can review the facts of the case. You have normal JR principles, so mistake of fact maybe, but beyond that, you're not going to be able to get into the weeds of whether or not, let's say, your coal mine is going to lead to greater greenhouse gas emissions. You don't get into those sorts of arguments. Those have been determined by a planning inspectorate, by the Secretary of State, and so on. And the approach, the Auchenbury approach, this composite approach to Article 6, has been touched on in recent case law. So Spurrier, which was the start of the Heathrow litigation in the divisional court, and one of the many Client Earth challenges, that's the reference there is to the challenge to the Drax repowering. It's touched on recently, but again, with no interrogation of the principles, all settles it. You've got this limited scope for judicial review. So that's where we are domestically, and I'll mention a few other ways in which these sorts of rights can be sort of vindicated domestically, and touch on a few of those other cases. But going then back to the Swiss case, which I call VKSS because I can't, my German pronunciation is appalling. The context, the question that's asked by the court is, are the proceedings, the litigation which is going on in Switzerland, are they directly decisive of a right to environmental protection? And in particular, are those environmental rights or the dangers serious-specific and imminent? And the court declines to say that it's going to rewrite Article 6 to talk about the way in which these rights need to be vindicated in the domestic courts, but leaves that open. While characteristics of the subject matter do not prompt the court to revise its established principles at this stage, it will have implications for the application of that case law. So a hint that maybe a slightly different approach needs to be taken. In particular, when looking at the rights that may be engaged, the court emphasises that this isn't just protection from harm, but also the wider protection of environmental rights which are safeguarded by domestic legislation. So, for example, rights to environmental information might also fall within the body of the rights that need to be protected under Article 6. And rejecting the proposition in that last bullet point that the harm in question needs to be strictly imminent. There may be a need to have vindication in the domestic courts or a right to adjudicate in the domestic courts, even if the harm is not imminent because of the subject matter we're looking at here. So, what did it say the scope of the Article 6 complaint was here? Well, in respect of the association's claim, it said that the broader arguments about legislative inaction were not capable of falling within the scope of Article 6. There wasn't an existing right there to adjudicate, but the failure to implement mitigating measures in accordance with domestic legislation was a matter which was capable of falling within scope. So inaction on the part of the Swiss authorities could fall within the scope of Article 6, and therefore the claim was about a civil right or obligation. And that brings in part the association, it brings into scope that part of the association's complaint. Effectively, the individual complaints fail for the same reasons that Alex has described under victim status. So what's the breach? First of all, rejecting, as we've already heard, the idea that this is simply an actio popularis, that this is litigation which is solely in the public interest. There are rights at issue. The failure of the domestic court, I think, is notable. What the domestic court failed to do was to consider the scientific evidence. And remember all those debates that we've had in the domestic courts about the scope of judicial review, how far should the court go considering and adjudicating on scientific evidence? Well, one of the failures was the Swiss court's failure to engage with that. Failure to grapple with standing, that's sort of parasitic on the points that Alex touched on. But also the administrative authorities were found to have failed in rejecting the complaints based on inadequate consideration of them. So you've got a sort of top-down view of that composite approach to Article 6, because the administrative authorities have failed to properly think about the impacts on these groups of people and on the association. But equally, the courts have failed to then grapple with the evidence which suggests that the administrative authority was wrong in its conclusions. So it probably doesn't go so far as to say that the sort of composite approach that has become orthodoxy in the UK when looking at Article 6 and the vindication of these rights is flawed. But it certainly hints that where you can say there's been a failure to grapple with the information, the subject matter of the potential harm to the climate, that there might be a scope for broader consideration in the application for judicial review. So again, if I go back to my coal mine example, if the true effects on climate change haven't been considered by the first instance decision maker, does the court then need to grapple more thoroughly with what those impacts actually are? And I think that will be the area of argument from certainly the planning and environmental field for challenging permits and permissions. The domestic reality, I just wanted to briefly, very briefly, because I'm running out of time, touch on a couple of cases, and just to sort of remember that often the court is faced with straightforward Human Rights Act claims in respect of environmental regulation. And Richards is a good example. That's the case about a landfill site and the potential risk from hydrogen sulfide emissions for a particularly vulnerable person who lived near the landfill site. And at first instance, the High Court gave this very broad declaratory relief, which looked a bit like the kind of relief we saw Strasbourg giving in this case, saying, well, the Environment Agency needs to go off and do this, this, and this to ensure no breach of Article 8 rights for the child in question. And the Court of Appeal stood firmly down on that and said, no, that's not what we do here. The courts do not operate in that way. We will not tell we may make a finding of a breach of Article 8, but it's not our job to tell the regulator how to go about doing its job. I think if you read Richards alongside VKSS, you can start to maybe see some of the tensions between the analysis of Strasbourg and the analysis of the domestic courts. But don't forget also on the other side of the coin, the Friends of the Earth challenge to onto this slide. The Friends of the Earth challenge to the Climate Change Act obligations, and that's in respect to the net zero strategy. And in that case, the High Court was willing to accept that all those obligations to develop a strategy to give effect to the budgets were amenable to review, but also that they could be considered quite closely and interrogated quite firmly. So that again, even domestically, you can point to cases that are going in different directions. I think the question there is probably going to lead to whether we lead to a more intensive scope for judicial review. And as I've hinted at, the question for me that arises from VKSS on Article 6 is whether it's sufficient still to take this sort of composite approach to review of those major planning and permitting decisions. And one of the areas that I think it might be particularly interesting is the sort of protection of policy. So in the Planning Act, if you go to court, you're not allowed to question the terms of national policy. It's precluded if you haven't brought a challenge to national policy at the time. But what if you say, well, hang on, national policy as it stands is going to not sufficiently address our climate obligations? Are you entitled to run that argument founded on a human rights case and thereby get around what would otherwise be an ouster of that sort of challenge in the court process? So I think that might be an area. The other area that I think I find fascinating as someone who promotes renewable energy projects most of my time is how are these questions going to deal with competing rights? Because I can tell you that nobody is turning up to the consenting processes for renewable energy projects saying, you must consent this because I'm going to suffer the adverse effects of climate change. But a lot of people come and say, you mustn't consent this because it's going to result in harm to my property, it's going to result in noise problems, it's going to result in electromagnetic interference, and all of those things. So all those planning arguments potentially can be seen in a different way if you say, well, hang on, there's an Article 8 right more generally at play here, which is to be protected from the adverse effects of climate change. So that's just some ideas as to how those points might come out in the future. Anyway, I must stop. Questions and answers.
Well, thank you very much. Well, there you are. You've got a pretty good overview of the issues and the problems. Do we have any questions or comments from those in the room? Yes.
I have lots of questions, but if I could try and ask a couple of questions very quickly.
Just say who you are for those listening.
I'm Sue Willman from Dyson Pierce Glynn and from King's Legal Clinic. I suppose this is a question for Alex. Do you think we could use the case to argue that an association should be able to get access to legal aid for access to justice in a climate case? That's my first question. Second question, thinking about the Finch case, we're waiting to find out if the Supreme Court wants to include downstream emissions. Could you now bring that case arguing Article 8? And my last question is about the difficulty that there isn't an environmental right in the convention, which is why we have this kind of artificial approach via Article 8 to get to an environmental right, because we hadn't thought of environmental rights when we introduced the convention. We now have this very strong finding about climate change, but what about other environmental rights? Do you think that this will kind of move those forward as well. For example, if we wanted to litigate for an association that's affected by a very polluted river, can we try and use this focus a bit more?
Right, well, there are three things there. Alex, you want to deal with the legal aid point?
Yes, at the moment I can't think of a reason why in principle that would be precluded. So I think I'll say yes, probably, on the basis that if there's, assuming you've got prospects and all the other tests are met, a human rights interference would ordinarily, if it was for an individual, be a circumstance in which legal aid would be available, given that the modest extension of the victim test is specifically to allow the association to bring the issue of the impact on numerous individuals before a court so as to adjudicate a human rights breach of all of them. It would seem a logical extension of that the legal aid provisions would be extended to it. But I'm going to have to go back and look at the regulations, but it feels like that's arguable from first principles.
The other two questions were more about whether you can extend the scope of this decision to deal with all issues like environmental assessment under Finch and environmental rights more generally. Do you want to comment on that, perhaps either Richard or Miranda?
Well, just on environmental rights more generally, I do think that this judgment, one of the reasons why I kept on talking about all the preamble in the background is it's very firmly located in science and international consensus around the climate crisis specifically and the urgency of action that is needed. So I think it would depend on exactly the nature of the environmental right. It's well established, as you will know better than I do, that if there were immediate harms being caused to individuals in your association due to, for instance, river pollution, that could manifestly fall within Article 8 even before this. But I think whilst this judgment confirms the fact that Article 8 remains this crucible of new rights, and if you're looking to create new rights, this is the place to do it. I think if you lack that immediacy of harm, I think you'd want to have real international and or scientific and or expert weight behind you in order to force the court to be creative and bold.
There was I was looking earlier, there was an interesting case that I hadn't read from end of last year called Locasia in Italy, which was about collecting waste and the strikes in the south of Italy that led to waste not being collected for months on end. And in that case, the court said that increased vulnerability to illness was enough to trigger the Article 8 obligation, which felt to me like a bit of an extension from that sort of established case law about noisy nightclubs in Spain and so on, which had been sort of, you've got to show an actual interference, you've been kept up in the middle of the night kind of point. It was enough for those people to say, well, everyone agrees I'm being exposed to disease. I don't need to actually get it to be a victim and to bring that claim.
Right, any other questions or comments from the floor here? I've got a question from the online audience. Yao Yang Neo. Could the ECHR case eventually change the process of UK planning law, or are the facts of this case too narrow to have such implications? What to say about that?
Well, I mean, I don't think it will, but I think there's room for arguments about this because, in particular, we are repeatedly told that when you go and argue about these cases in front of examining authorities for nationally significant infrastructure projects or inspectors on regulatory appeals or planning appeals, we're repeatedly told, well, you can't touch national policy. You're stuck with national policy. But I think the potential line of argument is saying, well, if I can show that this determination, even if in accordance with national policy, will nonetheless have a sufficiently adverse effect on the climate, I wonder whether you can start to say, I should be entitled to run those arguments as human rights arguments, even if not sort of planning policy arguments.
That's particularly in the context of climate change.
In the context of climate change.
I
I'm
mean,
thinking of emitting, the kind of schemes that are under challenge in the Cumbria coal mine case and in Finch, and I think probably most importantly in the extraction decisions for the North Sea, which are going to be the controversial ones.
Yeah, I mean, I think what the court has said in the Strasbourg case is that you need to have a set of legislation and policies and systems in place. And if you have that, then a supranational court or equally the domestic courts will be hands off. But I think in the long run, I mean, as it stands, we've got probably a system that most courts would say on a general level is perfectly adequate for its job. But the crunch points are going to come in 10 or 15 years as we get in a much more difficult position, as we enter the periods of the latest sixth carbon budget, and there's very little room left for the basic national industries that we want to continue with, like aviation, etc., that aren't going to be using renewable energy. How we cope with that is going to cause a lot of stresses around climate change arguments, and then this kind of judgment may come to maturation in terms of how it bears on the UK, because at that point the decisions we're going to have to make are a lot tougher.
That's a really good point. I think it is also worth putting in context that the failings by the Swiss government were quite fundamental, and the word irrationality sprung to mind when I was looking at the facts. The lack of a carbon budget, the lack of any kind of legislative framework to seek to reduce emissions over an absolutely key imminent period, and the government's own admission that they were failing to meet targets. So I think applying that in the UK context would be challenging.
I think that, for me, the more interesting point on that may end up being adaptation rather than about reduction of emissions, because I think that's going to be an area where we are going to come up against a crunch. Flood defences, cooling of social housing, for instance, those sorts of issues are going to start to become much more sensitive as we get into the reality of a changed climate.
But I mean, what you seem to be saying is in the context of UK, where we have a well-established Climate Change Act, which is being challenged, used as a basis for legal challenges, we won't have the sort of gaps that they found in the Swiss situation.
Yeah, I think on a legislative and policy level, we obviously have done a lot better than the Swiss. I think my caveat to that is you have to actually do things as well as just have legislation and policies. So, and we have done. If you look at the Climate Change Committee's reports, most of the low-hanging fruit has been plucked, and we have reduced our emissions by about half, or coming up to about half. So we have done stuff as well, but I think it's reaching that point now where the targets are much tighter.
And as you say, the low-hanging fruit has gone.
Yeah.
So it's now big and expensive, and I think from my sense is that if you look at the Friends of the Earth case on the net zero strategy, that's an example of Mr. Justice Holgate really rolling up his sleeves and saying, well, I've got the idea of the budget, but your strategy doesn't seem to have implementable measures on this, and this. So how are you going to go about doing that? And much like the air quality litigation that Client Earth brought 5-6 years ago, Mr. Justice Carnwath gave a series of judgments where he sort of kept sending the government back to do a bit more work on their strategy. And I think we're going to see a similar thing. I can't imagine these things will pass without legal scrutiny.
Yeah, but I think the point I was making is that those arguments under the Climate Change Act don't depend on the human rights. No. I wouldn't have thought they were strengthened particularly by this decision.
I think I'd agree with that. And as you know, the domestic courts, often when there's a pleaded human rights argument, they say, well, we don't need that to get there. get to that point.
Any other points from the floor? We're a diminishing group. Not putting in any more questions as far as I know. I'd like to, some of you may have seen the article by my former colleague Jonathan Sumption in the Sunday Times, in which he was very critical of this decision and said it really was a good reason, another reason for us to get out of the Human Rights Convention. What do you say about that?
Does it sound a little bit like confirmation bias, possibly?
I think that one of the answers to that is the elegance and genius, really, of how the Human Rights Act is drafted, because this is always overlooked, that we don't have to obey Strasbourg, and that's written very directly into all the mechanisms within the Human Rights Act. So if you don't like a judgment from Strasbourg, particularly as a Supreme Court judge, you can depart from it. There are ways in which we can do that, and the whole sort of sagas around prisoner voting rights and so on show that it doesn't require total compliance. So really, I think that's the simple answer, is that we've already cut all the balances in our domestic implementation of the convention.
I'd say it'd be a bit of a strange reason to run away from our human rights obligations. We've said that we want to be at the forefront of addressing the impacts of climate change, and that we want to be a country that leads on this rather than follows. So why run away from the idea that it is a fundamental issue that should be a matter of fundamental importance across Europe? I think we should be celebrating the idea that it's incredibly important. I think in terms of the way the domestic courts would approach it, as I've said by reference to Richards, I just can't imagine seeing that kind of relief in a domestic court, but that would be an easy step of reasoning to not give the same relief.
Well, I don't suppose Jonathan is out there listening to us. Michael Stellert has said, are there any cases that balance competing Article 8 rights, e.g. travellers' rights versus neighbour rights?
Yeah, well, actually, the cases about gypsies in the UK were in the back of my mind when I was reading this, because they're a similar structure. So Chapman and Connors were the two big Article 8 cases in the early 2000s, about 2005, I think they were. And that was a case, again, where the European Court was seen to be sort of leaping ahead in its understanding of Article 8, because it relied on a convention about the rights of minorities to interpret Article 8 so as to give some substance to the rights of gypsy and traveller minorities. And the structure of its reasoning there was actually quite similar, was that the UK didn't have a proper legislative and policy framework that gave effect to the positive obligation to facilitate their protected cultural and ethnic way of life. So it's actually quite a close parallel to what it's saying here, is we'll get, as a supranational court, we'll get involved where you just don't have a satisfactory framework at all. But we won't push much further than that. So it's not quite an answer to that question, but it is something connected to that question which I was thinking of when I was reading it. And of course, Article 8 covers balances between the rights of individuals and the rights of others. That's intrinsic to Article 8 in all of its manifestations.
Actually, I was very interested by this sort of balance in the Indian case, which we haven't discussed, but there the Indian Supreme Court was concerned with implementation of India's climate change policies, which involves constructing solar energy farms, wind farms, and so on, in a situation where the land for which is required for them happens to be the breeding ground of the great Indian bustard. And the case is all about the balance between the sort of climate change commitments and protecting the very important species, the great Indian bustard. It's a fascinating judgment, but I don't think I've got time to get into that. Thank you very much. Well done.
Thank you.
Thank you, everyone.